Good morning. I'm Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. You can call the first case.
Calling case number 250167555NO. Joyce Grant, a minor, by its next friend, Tarhan Grant versus Justin King.
Good morning. Can counsel place your appearances on the record?
Yes, good morning, Your Honor. Stephen Budai appearing on behalf of the plaintiff.
And good morning, Your Honor. Nakia Branch Benson appearing on behalf of the defendants.
All right. And I believe that Mr. Grant is here as well.
Yes, good morning, Your
Good
Honor.
morning. Mr. Grant, can you state your name for the record?
Yes, my name is Tarhan Grant.
Right, thank you. Mr. Budai, I've had an opportunity to view your amended motion for approval of settlement.
Yes,
All right. Is there anything you wish to state, or do you wish to voir dire your client?
I think we're ready to voir dire Mr. Grant.
Right. Mr. Grant, I'm going to ask you to raise your right hand. Do you solemnly swear affirm testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And can you once again state your name for the record?
Tarhan Grant.
All right. You may proceed.
Thank you, Your Honor. Mr. Grant, how are you related to Jace Grant?
That's my son.
And Mr. Grant, you were appointed the next friend for your son, Jace Grant, to pursue this lawsuit, right?
Yes, sir.
And how old is Jace now?
He's 13 at the time.
And you understand we're here today to settle Jace's personal injury lawsuit?
Yes, sir.
And you alleged in the complaint that Jace had been injured by the defendants, Justin King, who was an employee of the Detroit Public Schools Community District. And this was in December of 2024, while Mr. King was a security guard at Jace's school, and he pushed Jace into a locker or a wall at the school. Is that correct?
Yes, Your Honor. Yes, sir.
And in the course of those actions, Jace suffered a fracture of his right wrist. Is that correct?
Yes, sir. Yes.
Jace was placed in a cast, was eventually removed, and his injury has resolved. Is that correct?
Yes.
And what is his condition today? Is he still having any problems at all with his wrist?
No, not at this moment, no.
And the defendants in this case have offered $55,000 to settle the case, and you've indicated you want to accept this sum on behalf of your son. Is that correct?
Yes.
And do you believe that this settlement is in the best interest of your son, Jace?
Yes, I do.
And you understand that certain amounts are going to be deducted from that settlement, $576.90 for costs that I've spent on this case, as well as a reduction for attorney fees in a reduced amount of 25%, which is $13,605.77. You understand that?
Yes.
And you agree to that?
Yes.
And the balance of $40,817.33 is going to be dispersed pursuant to a structured settlement. Do you understand that?
Yes.
And you were involved in determining the terms of that structured settlement, correct?
Yes, I was.
And the structured settlement is going to be $10,000 paid as a lump sum at Jace's 18th birthday, which is June 17th, 2030, plus $500 payable monthly, which is guaranteed for 3 years, commencing the next month after his birthday, and will go for 3 years until June 17th, 2033. And then finally, there will be a lump sum of $26,697.35 paid to Jace on June 17th, excuse me, Your Honor, June 17th, 2036. Is that your understanding?
Yes, it is.
And that's the structure that you wanted set up for your son. Is that right?
Yes.
And that will be through the Pacific Life and Annuity Services, Inc., payable to Jace under the, as I just stated on the record. And are you asking Judge Smith to approve this settlement in the amounts that I've stated and for payment to Jace as well as payment of the attorney fees and costs?
Yes.
Okay. I have nothing further, Your Honor.
Okay. Ms. Branch Benson, do you have any questions for Mr. Grant?
I do not, Your Honor.
All right. Mr. Grant, do you have any questions with regard to the settlement?
No, I do not.
All right. May the record reflect, I've had an opportunity to listen to testimony of Mr. Grant, who is the next friend to Jace Grant, the minor. I'm going to grant the motion to approve settlement. If you will submit an order.
I will be submitting that order. We've already approved it between us. I'll submit it in just a couple of minutes.
All right, fantastic. Have a good day.
Thank you, Your Honor. You too.
Thank you.
Thank you.
Calling case number 25-002-161 NI. Amira Hunter versus Progressive Marathon Insurance Company et al.
Anyone here on the Hunter matter? No, we can pass over that one.
Calling case number 25-009-313 CH Perfect Fit Realty LLC versus Antoine Johnson et al.
Good morning, Your Honor.
Good morning.
Marvin Wilder, P53871, appearing on behalf of Perfect Fit Realty LLC.
All right, and this is your motion for default judgment, quiet title?
Yes, Your
Okay.
Honor. We filed a motion because there was a fraudulent deed in the record of deeds
Mhm.
against the property owned by my client. We don't believe that these people are they could be fictitious people, but we were not able to serve them. We did receive an order for alternative service, which we did effectuate publication in the Detroit Legal News. We have submitted a copy of the motion for default judgment at that address, at the last known address. And so we would ask that at this point, we just get a default judgment as to Antoine Johnson only, and it's only to quiet title. No money damages are being asked, and we will voluntarily close the case after that.
Okay, and to the other defendants, Andrea, is it Gray and Monica Doyle?
Yes, we will dismiss
Dismiss.
the balance of the case.
All right, thank you. May the record reflect, I've had an opportunity to view this motion. This is plaintiff's motion for default judgment to quiet title to property located at 19346 Buffalo Street in the city of Detroit. There was an order for alternate service. Publication occurred on November the 6th, the 13th, and the 20th by way of Detroit Legal News. Since that time, defendant Johnson has failed to file an answer to the complaint or response to this motion. I will grant your motion for entry of default judgment to quiet title. If you will submit an order.
Your Honor, I have a order that is Exhibit 9. I will resubmit it and
Yes.
take off the word proposed. And
All
I'll
right.
submit that immediately.
Fantastic. Have a good day.
Thank you, Your Honor.
Calling case number 25-014-115 NF Farmers Insurance Exchange versus KD&D Inc.
Good morning, Honor. Excuse me. Good morning, Honor. Blake Carmichael for Plaintiff Farmers.
All right, and this is your motion for entry of default judgment?
That's correct.
All right, anything you want to state for the record?
Your Honor, this stems from a February 2021 accident against the defendants KD&D Inc. The claimant, Natoya Varnell, was injured in a transportation vehicle that was uninsured. Her benefits were then assigned to the MAIPF, who assigned it to farmers. In addition, the defendant's resident agent was served with the summons and complaint on September 13, 2025. Which is attached as Exhibit C. Defendant was also served with a default affidavit on November 13, 2025 via first-class mail as well. I've not heard anything from them or any of their representatives, and they did not appear today, so I'm asking for a judgment in the amount of $32,154.84, which is supported by the adjuster affidavit as well as the pay log attached to our motion.
Is it 84 cents or 85 cents?
I believe it's 85. Let me double check.
That's what my notes indicate.
I think it's 85, Your Honor.
All right, fantastic.
Yes, 85.
Right. May the record reflect, I've had an opportunity to view this motion as well as hear oral argument. This is plaintiff's motion for entry of default judgment. This is a subrogation claim as to defendants who were the owners of a 2007 Chrysler Town and Country that was uninsured at the time of this motor vehicle accident. As a result, the plaintiff paid PIP benefits as well as some other costs at this time. The defendant there was proof of service filed with the court. Defendant failed to file an answer to the complaint. A default entered on November the 12th, 2025. Since that time, defendant has failed to file an answer to complaint or response to this motion. The court will grant plaintiff's motion in the amount of $32,154.85. You may submit an order.
Thank you, Judge. Have a good weekend.
You too.
Calling case number 24018-629 NZ. Luis Antonio Martinez Sr. et al. Versus Wayne County Medical Examiner et al.
Good morning, Your Honor. Jason Killips for the defendants.
Good morning, Your Honor. Julie Hurwitz and Matthew Arard. Sorry. Appearing on behalf of the plaintiffs.
You know, you've got a lot of feedback.
I understand that. Bear with me for one moment, Your Honor.
Okay. If you have some other devices on, you can get a lot of feedback.
I think we're all set. Is that
We're
better,
all
Your
set.
Honor?
Yes, if you could just place your appearance on the record again.
Yes. Sorry about that. Julie Hurwitz and Matthew Arard appearing on behalf of the plaintiffs. There are two motions before the court this morning, Your Honor. Plaintiff's motion to extend the discovery deadlines and the defendant's.
Before you continue on, I was just wondering, have you all had an opportunity to speak about these two motions?
Very much.
Okay, all right, go ahead.
And I just wanted to represent to the court that between the two motions, I will be arguing the motion to extend the discovery deadlines, and
Okay.
Mr. Arard will be arguing the motion, the defendant's motion to compel.
Okay, go ahead.
And Your Honor, we've had our motion to compel on file for a couple of weeks. So if it's all the same to the court, we'd like to go first, if that's all right.
Any objections?
No,
Okay.
Your Honor.
All right, this is defendant's motion to compel discovery from plaintiffs. Go ahead.
Thank you, Your Honor. And really, the two motions here share a theme, and that theme is plaintiff's delay here. We have resolved half of the motion to compel, which relates to the notes. Now, we'd been promised those notes for some time, tomorrow and tomorrow and tomorrow. We finally got them after 6 p.m. yesterday. But that part has been cleared up. But we still have this issue of the expert and his opinions and the bases for those opinions. We requested that discovery back in July. It's been due for months. And the plaintiff's only excuse is, well, we haven't gotten our expert to work yet. Well, Judge, it's the end of discovery on track 3. The plaintiffs have the burden, and they either have to produce their expert discovery or, I think, drop their expert. Now, we have been discussing over the last few days, as you inquired about, whether we could resolve this motion and actually some other discovery issues between the parties as well. And as part of that, the plaintiffs did offer to produce this expert discovery by Friday, February 6th. That works for us, but after all the promises that keep leading to delay and delay and delay, we would like an order saying that, Your Honor.
Okay, response? Oh, you just have to unmute your microphone. I can't hear you. You got to unmute your microphone.
Can you hear me now, Your Honor?
Yes, yes.
Okay, thank you. We are not opposed to February 6th. We would be accommodating that date with or without a court order, and it is simply because that is the date on which our retained expert is able to provide us his opinions for purposes of answering that interrogatory. We have never had any intention to deprive the defendants of a complete response to their interrogatory, to provide our expert for their deposition, or to provide the interrogatory in advance of that deposition. But as the court knows, expert time is not cheap, and it is. We figured it was important to have the expert review all of the discovery as contemporaneously as possible, and that required complete completing the bulk of that discovery, including depositions, which I think have run into just the past week as far as getting transcripts. And so our experts, we have a date certain of February 6th, on which we'll have that answer. And it has always been our intent to provide that as soon as we can get that information. But to do so before we have that information from our expert, as the defendants seem to seek, would it in itself be sanctionable conduct? And the Michigan Court of Appeals addressed that squarely in Jackson County Jackson County Hog Producers versus Consumers Power Company, where I believe the producing party or the responding party was sanctioned for misleading the party fielding the interrogatory into thinking that their experts' opinions had already been rendered when they in fact had not. I think it's certainly in the interest of everyone, including opposing counsel, that they get the most accurate description as possible what our expert opinions actually are, and that requires giving our experts the opportunity to form those opinions upon a complete review of the record.
All right. I've had an opportunity to listen to oral argument. The reality is that defendants been waiting for this information since at least July of last year. The case is over a year old, so I certainly understand defendants' position is they want to make sure that they get the documents that have been promised. So I'm going to grant the motion. The answers to expert interrogatory are due February the 6th, 2026.
Thank you, Your Honor.
All right, next motion.
Yes, Your Honor. Julie Hurwitz, on behalf of the plaintiffs, on our motion to extend the deadlines. I do want to clear up one factual, it's not an error. Well, it is an error because this case, while we filed this case in December of 2024, we granted the defendants 2 separate extensions before they even filed their answer. So that didn't get filed until May of 2025.
I understand that was part of your motion.
And that's when discovery really started in this case, was in within the month after the answer having been filed.
Which means everybody's going to have to step it up in terms of discovery. That's what that means, because we all have deadlines. But go ahead.
We understand that, Your Honor, and the parties have been vigorously engaged in discovery ever since that time, with the service of multiple requests for production and interrogatories, as the court has already heard as to one. We also have taken, as I indicated in our motion, I think up 11 or more depositions. The last deposition in this case is still was last week, and there's another one scheduled for this afternoon. We have been working with Mr. Killips and his firm to schedule the deposition of our expert, Dr. Dragovich, who was going to make himself available on February 13th, but the defendants notified us that date was not going to work for them any longer. So we have just given them some new dates that our expert will be available. And it's really the issue here, Your Honor, is that we still have not received several items ourselves in response to our discovery requests. We've been waiting for the employees' personnel files that we've been told will not be produced because until a protective order is entered. We've been hashing out between ourselves the language to stipulate to the entry of a protective order. Nobody disputes that that's appropriate. We're still working on finalizing the language of that protective order. But meanwhile, there's nothing stopping them from producing the personnel files. Just designate them as confidential and they'll be covered by the protective order that will get entered. We're still waiting for the insurance policy that was in effect as of the date of this incident. The defendants have produced an insurance policy that post-dates the incident starting in 2022, and Mr. Martinez's son's body was the issues that gave rise to this lawsuit occurred in 2021. We've been, as the depositions have been undergoing as well, Your Honor, we have been learning new information as we've gone along. Just last week, for example, the defendants took the deposition of the funeral home director, a man by the name of Ray Alec, and we learned from him at that time of the identity of two people, neither of whom we even knew existed before he indicated who they are, as handwriting that showed up on documents that were subpoenaed back in July that we didn't even learn about from defense until one of our clients was deposed, and they produced all these documents, and we learned for the first time in November that they had served a subpoena on this funeral home in July, and they never notified us of the subpoena, which is a violation of the court rules, as the court knows. We're also waiting. They've now served an amended witness list without seeking leave of the court, in which they identify for the first time a Dr. Hung, who's the current medical examiner. His name has never shown up on any prior witness lists, the original witness list. And then they included a lengthy statement in this amended witness list in which they talk about experts that they are reserving their right to name, and we still to this day don't know the names of any experts that they intend to use. And I find it hard to believe that this is a very straightforward case, Your Honor. It has to do with the medical examiner's office blatant violation of the Michigan law and standard of care for what they are required to do when they come into possession of a body. And in this case, they allowed this body, who was the loved one of the plaintiffs in this case, who showed up on February 3rd, 2021. That's when he died. And he arrived at the medical examiner's office at like 4 in the morning on February 4th. And they immediately, he arrived as a John Doe, but within 24 hours, they knew who he was. They took his fingerprints, they identified him, and they compiled a list of all of his next of kin. They identified who they were on February 4th, 2021, and nobody, not one person from the medical examiner's office took one step. There's no record of any attempt to notify the next of kin, and none of them were ever notified. And they learned on their own over 2 months later, after which, because he was stored in a way that was improper and at too high a temperature, his body was so seriously decomposed that the family couldn't even view his body by then. And that's really what this case boils down to. The defendants know what the experts are going to be talking about, and yet they're refusing to disclose the identity of anybody they intend to use as an expert. So there's all kinds of new information coming up from the discovery that is ongoing, and we're simply asking the court to extend the deadlines to allow us to do the appropriate follow-up that it will be necessary to adequately prepare our case for trial. And so we've asked in our motion for a 90-day extension, and we think that that is reasonable to allow us to do the expert discovery that needs to be done. It's really quite usual for expert discovery not even to begin until the completion of fact discovery, because it's the experts do need to have available to them all of the evidence that they're going to be relying on to formulate their opinions. And as in this case, it's not uncommon for that evidence not to be completely obtained until fact discovery is over. So we don't think it's unreasonable for there to be an extension of these deadlines to allow all the parties an opportunity to wrap up and complete the discovery so that we can go into facilitation or mediation and be in a position to meaningfully engage in an effort to try to get this case resolved. Thank
In
you.
response?
Yes, Your Honor. I assume you don't want me to get into the merits of the case itself. I'd be happy to do that at some length if you would like, but suffice it to say there's a lot of evidence that contradicts a lot of what Ms. Hurwitz just said as far as the merits of the case itself. But let's focus on the motion to extend here. Your Honor, we're already on track 3. Discovery is set to close next Thursday. Every deposition that the plaintiffs have noticed has already been taken. We have produced more than 1,200 pages of documents in this case, and there's more to come that are due to be produced next Thursday, yet they want 90 more days. Really, Judge, to do what? They have failed to identify a single piece of discovery that they could not complete with reasonable diligence and planning during the discovery period this court set and extended twice for them. Basically, it comes down to saying, well, we might have more questions. Well, every lawyer can always ask another question. That's not an excuse for extending discovery beyond track 3 on the court's scheduling order. I want to address quickly a couple of the very particular things that Ms. Hurwitz brought up. She mentioned these personnel files and this protective order. Judge, again, we sat down with Ms. Hurwitz and Mr. Erard last Thursday to discuss this protective order. We promised to get changes to them the next day. We did that, and it has languished on their desk again for a week. Since October 9th, when we proposed it, we've had that ball, if you will, in our court for a matter of days. They have had it on their desk for more than 3 months. This delay is not on us. And as soon as we get that protective order entered, they can have the personnel files. As far as the insurance policy and their position that it's the wrong one, this is the first I have ever heard of that, and I will be happy to look into that for Ms. Hurwitz, but that doesn't justify the extension of discovery either. And finally, as to these 2 people identified in the deposition the other day, they're people who filled out some forms at the funeral home. Just because they're the people who filled it out doesn't have anything to do with this case, even in Ms. Hurwitz's version of the story. So that doesn't justify an extension either. And Dr. Lockman Sung is not some new party that we've identified as an expert witness for the first time. He's the Wayne County Medical Examiner. That's the first defendant listed on the caption of this case. Ms. Hurwitz sued him in his official capacity. All we have made clear on the amended witness list is simply that since you won't tell us what your experts' opinions are, we guess we might have to have rebuttal testimony, and this is somebody we might have to have it from. But it's a little rich for the plaintiffs to say, on the one hand, we can't possibly explain our opinions to you during the discovery period, and on the other hand, demand that we identify rebuttal experts by just guessing what their opinions are ultimately going to be. Judge, the plaintiff's lack of diligence and planning here is not an excuse to extend this discovery period. The issues that are outstanding between the parties can be resolved either between them or with this court's help if that unfortunately proves to be necessary. But there is no need to extend this case further. Thank you.
I just had a question with regards to your amended witness list.
Yes,
Seems
Your
to
Honor.
me that was filed after the deadline. It's my understanding on track 3, the witness list was due December the 4th, and your amended witness list was filed January 16th.
That is true, Your Honor.
Without leave of the court?
That is also true, Your Honor. We didn't add anybody to it, though. All we did was clarify to put them on notice who these potential rebuttal experts could possibly be, not knowing what their expert is going to even opine on, much less say.
So there was no new witnesses.
There is no new witness, Your Honor.
That's not correct, Your Honor.
Okay.
Your Honor, the only potential person they might see as a new witness is Dr. Lockman Sung, and he is the first defendant on the caption.
Oh, okay.
That's
All
not
right.
true either, Your Honor.
All
He's
right,
not named.
this is what I'm going to do. I've had an opportunity to listen to oral argument. I've also reviewed the motion to extend discovery. As I've indicated already, this matter was filed before the court on December the 26th, 2024. Now, there was a delay in the defendant getting into the case and filing an answer to the complaint. However, as I've indicated, you've already been extended out to track 3. The case is over a year old. I am going to deny plaintiff's request. However, what I'm willing to do is I'm willing to continue discovery to case evaluation that's currently scheduled for April the 20th, 2026. You got to get the discovery done by then. I am also willing to extend the witness exchange date to February 13th, 2026. So you'll have that time in which to file any amended witness lists. And my suggestion to defense counsel is that you refile your amended witness list because it wasn't proper. It was filed after the witness list the witness list deadline. I am going to order you to facilitation. Your facilitation to take place by June 26, 2026. So you go to case evaluation, you'll have an opportunity to present your case to the evaluators. They'll give you a number and then you'll have time to accept or reject. If you both or one of you rejects, then I will expect you to go to facilitation, decide on who you're going to facilitate with, and get on their calendars before then. So the facilitation is to take place by June 26, 2026, and I'm going to schedule you for a settlement conference with me for July the 14th, 2026 at 9:30 via Zoom. If you can check your calendars for the settlement conference date just to confirm that you are available on that date. It is during the summertime, and perhaps if you have any vacation time you want to let me know so that I can give you a date that you'll be available.
That's good for me, Your Honor.
Okay,
One moment, Your Honor.
all right.
Are you July 14th? That's the date you're asking about?
That is correct. July the 14th, 9:30 via Zoom.
Yeah, that's fine. Does that work
All
for
right.
you? Yes.
The
that-
other issue that both of you raise is in terms of some discovery issues. I'm going to refer you to the mediation tribunal, to a discovery master, and most of the time it's going to be a retired judge. If you continue to have some discovery issues, then if you will contact my office, I will prepare a referral and you can go and speak to a discovery master. So that's my suggestion, so that way you keep this going in terms of discovery. Anything else?
Your Honor, can I just confirm all those dates with you real quick to make sure
Go
I've
ahead.
got everything right in my notes?
All right,
So the motion to extend is denied, but you are extending discovery through the case evaluation date, which is April 20th of 2026.
correct,
There's a new witness date of February 13th of 2026. So at least in my case, I better refile that witness list.
correct,
We're to facilitate, by 6/26, June 26 of 2026.
correct.
We can work together to choose the facilitator. And then a settlement conference on June 14th of 2026 at
No,
9th.
no,
Sorry, July.
Yes,
My notes are correct. My speech is not. I'm
Okay.
a little low on coffee this morning.
Yep.
9:30 in the morning. And then if we have further discovery issues, we should contact your office for a referral to a discovery master.
right. And the discovery master with the mediation tribunal is at no charge to either party.
Understood completely, Your Honor. Thank
All
you.
right. Anything else? Nothing
Not on
else?
my
The
end.
meeting is adjourned.
Question, Your Honor, is
Go
the
ahead.
court going to generate the order or do you
No.
want an order submitted?
No, you both have to submit orders.
Okay, will do.
All
Your
right.
Honor.
Nothing else? Matters adjourned. Have a good weekend.
Thank
Thank
you, Your
you.
Honor. You too.
Thank you.
Bye.